3, 2, 1, ready, start. It was further submitted that under the Act of 1956, a person, through confined to Hindus as defined in the Act, is bound to maintain his or her legitimate or illegitimate children and his infirm or aged parents, while the provisions of Section 125 CRPC and now Section 144 of BNSS do not define the term maintenance or parents, but the said provisions uses the terminology of providing maintenance inter alia to father or mother who is unable to maintain himself or herself, and in such cases, monthly allowance for interim maintenance and expenses for the proceedings can be awarded by the magistrate concerned. It was urged that Section 125 CRPC is a general provision available to all citizens irrespective of their religious orientation, however, in contradistinction, the Act of 1956 is available only to Hindus as defined in the Act of 1956. Despite the availability of provisions in law for maintenance, an emergent need to address certain pressing issues for providing cares for the elderly was felt. Noticing a gradual shift in the societal composition, leading the older generation to spend most of their later years in recluse, which exposed them to emotional neglect, and in many cases, it gave rise to maltreatment by restoring to physical, financial and emotional neglect and abuse. These issues were becoming a challenge for the society, hence, in order to address such concerns, the Act of 2007 came into being. It provides for creation of a maintenance tribunal which is required to consider the issue of maintenance as defined in Section 2 (b) of the Act of 2007, but such a tribunal has not been vested with any power to pass an order of eviction. It has also been submitted by Sri Chauhan that this issue was also under consideration before the Parliament and during the debate on the said bill, which later came into being as the Act of 2007, it was observed that the matter relating to protection of life and property of a senior citizen parent, basically pertains to law and order, and this is state subject, hence, it was left open for the respective state governments to examine the issue, and if they deemed appropriate, they could have legislated on the aforesaid aspect while framing the rules. Therefore, the issue of eviction from a property was consciously left out from being incorporated in the Act by the Parliament, and in the instant case even the state government has not incorporated or provided for any such powers to either the maintenance tribunal oblique appellate tribunal or the district magistrate as the case may be. Stop para. It was next urged that Section 23 is stand-alone provision and in order to invoke the same, the necessary conditions as engrafted in the said section have to be first ascertained. Stop. If the said conditions do exist, only then the tribunal in a befitting case may pass an order as envisaged in the said section and as a concomitant, a limited order of restoring possession to the senior citizen oblique parent may be passed, however, it cannot be said that the tribunal as a matter of course, has been vested with powers to order an eviction of children, relative, or a third party. Stop para. It was further submitted that looking into the provisions of the Act of 2007, it would indicate that the appellate authority constituted in terms of Section 15 and 16 of the Act of 2007 has distinct and limited powers which is confined only to assess the validity of the orders passed by the maintenance tribunal. Stop. Even though the district magistrate has been designated as an appellate authority, the powers of a district magistrate while it acts as an appellate authority under the Act of 2007 are different than the powers which a district magistrate exercises as an authority appointed by the state government for ensuring that the intent and the purpose of the Act is achieved. Stop. This can clearly be discerned from the language of sections 15 and 16 which relate to the powers exercised as an appellate authority, which is in contradistinction to the language used in section 22 of the Act of 2007 as well as the rules made by the state government in exercise of powers under section 32 of the Act of 2007. Stop para. In this view, it was urged that the district magistrate does not appear to have been conferred with powers to pass an order of eviction unless it is held that the power of eviction has been conferred upon the district magistrate in furtherance of the comprehensive action plan as referred to in section 22 of the Act of 2007 or the rules framed by the state government in exercise of its rule-making power. Stop. It was also submitted that the power of eviction is neither conferred on the maintenance tribunal nor on the appellate authority, which exercises powers under section 16 of the Act of 2007. Stop. Besides the aforesaid, the district magistrate has not been conferred with any adjudicatory powers.